Honourable Senators, we're resuming in public to continue our study of Bill S-250. And for our second panel, we're very pleased to welcome today from the Native Women's Association of Canada, Sarah Nyman. Is that correct? Nyman? Senior Director, Legal Services. And from the Women's Legal Education and Action Fund, Pam Hrick, Executive Director and General Counsel. So welcome and thank you for joining us. And we'll begin with opening remarks from Sarah Nyman and then from Pam Hrick. So both of you, the floor is yours for 5 minutes when you are ready. So we'll start with Ms. Nyman.
Thank you, and hello, bonjour, honourable committee members. Thank you for inviting NWAC to speak here today on your study of Bill S-250 on unsurrendered, unceded Algonquin territory. I also want to thank Senator Yvonne Boyer. Thank you. You've tabled this legislation on behalf of survivors of forced and coerced sterilization, and I want to thank all of the honourable senators for taking a united approach to this bill, because this human rights violation is one for which we all share a collective responsibility. I am honoured to be here to speak on behalf of NWAC in support of Bill S-250. It's a travesty that this bill is necessary, and it is imperative that it is enacted. This bill honours the survivors and the next generation of Indigenous children by acknowledging that those who sterilize Indigenous women by force or coercion are criminals and cogs in colonial machinery, and it is high time that this country's legislation reflect that. Forced sterilization of Indigenous women is an act of genocide. NWAC supports enacting Bill S-250, and it is long past due. NWAC does not want to impede its progress. In addition to this bill, however, NWAC calls on the Honourable Senate to consider drafting additional legislation and a national action plan, because this approach will further address the outstanding issues and concerns related to forced sterilization. I would be remiss as NWAC's advocate if I didn't share sort of our top 10 issues that remain to be addressed in order for this legislation to fully align with the UN Declaration and with Canada's stated commitment to reconciliation, recognizing that those most disproportionately impacted by forced sterilization are a marginalized group. 1, survivors deserve a formal apology and acknowledgement by the Government of Canada. 2, reparations. Healing from genocide requires financial, cultural, and emotional support, and this support needs to be trauma-informed and led by the survivors. 3, Indigenous women need culturally safe and trauma-informed reproductive health services in their communities. To ensure that the threshold of free, prior, and informed consent can be provided, Indigenous language interpreters must be funded and available at these healthcare facilities. Healing. We need to develop and fund an advisory council to assist the women who have experienced forced or coerced sterilization to facilitate their healing. 6, accountability. We need to help Indigenous women lead the measures to hold the medical authorities, the federal and the provincial governments accountable. 7, education. We heard earlier about the importance of going beyond criminalizing these assaults by training and educating all our healthcare providers on the Indigenous cultures, human rights, Indigenous rights, and Indigenous reproductive health issues, and what free, prior, and informed consent means. 8, data collection. Develop a Canada-wide data collection system to better understand the scope of forced and coerced sterilization. 9, investigate. A transparent, trauma-informed Canada-wide investigation conducted in collaboration with Indigenous people and survivors, examining forced and coerced sterilization so they never happen again. And 10, legislative amendments. In addition to those proposed through Bill S-250, NWAC believes it's important to investigate and identify what other relevant acts need to be amended to make sure that S-250 can be effective. We raise as an example, the Canada Health Act could be amended to pass further regulations requiring provinces to update how they will address forced and coerced sterilization with the coming into force of Bill S-250. Notably, Bill S-250 does not provide a redress mechanism. For several years, NWAC has been advocating for a system of redress to survivors of forced and coerced sterilization. We believe that the legal framework advising this is found within UNDRIP Article 8, and it paves the way for Canada to reconcile this haunting tragedy and aligns with Canada's obligations under the UNDRIP Act. Putting money through redress on the table, does not undo the harms, nothing can. But it signals an urgency to provide redress for those Canada has abused so terribly. NWAC remains available for further questions on these remarks or other concerns that this committee may have. Thank you and miigwech.
Thank you very much. Now we'll go to Ms. Rick.
Good afternoon. My name is Pam Rick. I am the Executive Director and General Counsel of the Women's Legal Education and Action Fund, or LEAF. I'm grateful to be here with you today on the traditional and unceded territory of the Algonquin Anishinaabe people. And I also want to acknowledge the contributions of my colleagues Kat Owens and Lulu Mary in their work preparing for this appearance today. As many of you know, LEAF is a national charitable organization that uses litigation, law reform, and public legal education to advocate for the equality of women, girls, trans, and non-binary people. We do this, and we have been doing this for almost 40 years now. Thank you for inviting me here today to speak about Bill 250. I would like to acknowledge the courage of the survivors who have spoken out, including before this and other Senate committees, to demand an end to the practice of forced and coerced sterilization. I would also like to commend Senator Boyer's leadership in bringing forward this bill. As this committee has heard, forced and coerced sterilization is a human rights violation and a crime disproportionately committed against Indigenous women. Black women, disabled women, poor women, and intersex children have also been targeted for forced and coerced sterilization in Canada. This practice is a profound violation of gender equality and bodily integrity grounded in racism, colonization, ableism, and sexism. LEAF supports the introduction of a criminal code offense that specifically targets forced sterilization and coerced sterilization. We do not do this lightly. As members of this committee have observed, the criminal legal system has both failed to protect and caused harm to members of marginalized communities in Canada, in particular Indigenous, racialized, and disabled women. The offense provisions in this bill, however, are most likely to apply to healthcare providers who hold positions of power, privilege, and trust relative to their patients. The introduction of a specific offense will leave no doubt as to the illegality of this practice. It will play an important deterrent and communicative role for medical professionals, regulatory bodies, and professional associations. It is important that any offense apply in narrow and targeted circumstances. The definition of sterilization procedure included in this bill encompasses acts, quote, for the primary purpose of, end quote, surgically or permanently preventing conception. It does not encompass acts that result in the prevention of conception, but have a different primary purpose, such as treating medical conditions like cancer, uterine fibroids, or endometriosis. In addition, as Senator Boyer has noted in her testimony, many people may want to undergo sterilization procedures. This bill allows them to ask for these procedures and, critically, to consent to undergoing them. We would, however, recommend amending the bill to remove the bar on consent for persons under the age of 18. This would be in line with the standard approach to consent to healthcare procedures for minors, which focuses on whether they can understand the nature and purpose of treatment and the reasonably foreseeable consequences of it. Legislating a minimum age for consent in the circumstances, we believe, would open the door to age restrictions on consent to sexual and reproductive healthcare procedures such as abortion. This bill is an important starting point for prevention and accountability. However, as Ms. Nyman has said in her opening statement, all levels of government, as well as non-government actors in the healthcare and education sectors, must take steps to end forced and coerced sterilization. There needs to be further research and disaggregated data on this practice. There needs to be a framework for reparations. The Government of Canada must issue a formal apology to survivors of coerced and forced sterilization, including survivors like Ms. Rabbit, who spoke before this committee. We must also do more to combat systemic discrimination in healthcare and ensure equitable access to that care. This will include increasing representation within healthcare, including through Indigenous and community-based midwifery. It will require providing anti-racist and cultural competency training for all healthcare officials and providing properly trained medical interpreters. It will require providing equitable access to comprehensive, culturally safe education on sexual and reproductive health. Thank you for your time, and I look forward to your questions.
Thank you very much. Appreciate that from both of you. Okay, we will now proceed to questions from members. We'll have about 4 minutes for each. So if you could please confine your exchanges as possible to that. We'll start with Senator Boyer, the sponsor of the bill, and following Senator Boyer, we'll have Senator Dalphond.
Thank you, Madam Chair. My question is for you, Sarah. So NWAC has continued to be a strong advocate for the reproductive rights of Indigenous women, girls, Two-Spirit, transgender, and gender-diverse peoples in Canada. In your opinion, how do you envision the implementation of Bill S-250 to contribute to the empowerment and autonomy of Indigenous women and girls in making decisions about their own reproductive health?
Thank you for your question. NWAC has heard from the Indigenous women and gender diverse folks that we have consulted with that they already understand that they have the right to their own bodily autonomy. But what Bill S-250 does is it codifies it and ensures that there is a penal sanction, a criminal penal sanction, for those who would violate that right. As my submission summarized, this approach needs to happen in concert with a multifaceted approach to dealing with the systemic discrimination that was the breeding ground for forced and coerced sterilization.
Okay, thank you.
Anything further? Okay, thank you. Senator Dalphond, followed by Senator Prosper, please.
Thank you, Madam Chair. Welcome again. And I said to them when I walked in, I said, I think I recognize you. You've been here before a few times. And the reply was, it's 5 times before. So we have a group of recidivists before us, in the good sense.
Well,
thank you very much for coming again. We appreciate always. And my question is to follow up, Mrs. Eric, about the age, and also to add to it because you said your group also speaks for trans people. Is there a problem? Because I think Senator Simons raised that issue maybe yesterday or the week before at the previous meetings, and the way that it's defined the sterilizations, it could target somebody that wants to have a sex change, and including removing, transforming from a woman to a man or something else, and that will imply some form of sterilization. So was that a concern to you and to your organization? So I have 2 questions: the age limit, which you start to explain, and some people that would like maybe to have a surgery in the process of a transgender issue, and they are not yet 18, for example.
So I'll take the first question first, take them in order. So with respect to the age limit, what we would say is that this is a matter of sexual and reproductive health care. And so the approach, we would want to be consistent with general delivery of that, but having a very targeted approach to the harm that is really underlying what this bill is trying to address. So in the common law, generally, you would operate with under a doctrine of the mature minor doctrine, and so that governs consent to medical care, and then the focus would be on whether the minor is capable of consenting. We don't think that there would be a broad swath of folks under 18 who would seek a sterilization procedure for the primary purpose, and I want to focus on that language, the primary purpose, which I think is a good thing about the way this legislation is drafted, for the primary purpose of permanently preventing conception. So those are sort of some of the rationales for wanting to suggest removing the age limit, and because we wouldn't really favor setting the precedent that might allow for age limits to be set in criminal law for other healthcare matters as well. For the second part of your question, with respect to what I think can very more accurately be called gender-affirming care, when this is something that has come up for us in our consideration of our position on this bill as well. What we appreciate about the bill, again, is that it is quite targeted. We go back to that primary purpose being the prevention of conception. And so for gender-affirming care procedures, there's a broad swath of them that would not, I think, come anywhere near that particular definition, and where there would be, for minors in particular, in the very, I guess, very, very, very rare circumstances where such an intervention would take place, I also think that it would be clear the purpose of this bill is not meant to prevent gender-affirming care, and gender-affirming care is meant for the primary purpose of affirming one's gender rather than preventing conception. That is what my response would be.
That's why you said I favor a very narrow interpretation.
Correct.
Based on the goal of the bill.
Correct.
Thank you.
Thank you very much. All right, we'll now have Senator Prosper, followed by Senator Carignan.
Thank you, Madam Chair, and thank you to the witnesses for providing your testimony. I have a question for Ms. Nyman. It's along the lines of informed consent, and I understand there's a number of considerations in that regard when we're talking about marginalized groups, Indigenous women. You talked about interpreters, for example. I'm wondering what other considerations do you find relevant when we're discussing the subject of informed consent? Thank you.
Thank you for the opportunity to speak on this. NWAC has done significant amounts of research, especially in the field of healthcare, about what informed consent looks like, given the rampant discrimination against Indigenous women within the healthcare. You asked for sort of examples of what that might look like. In some situations, it would be, or in the situation of future fertility choices, that might look like having a conversation well before the anticipated date of delivery that says, these are the options that you might want to consider. This is all the information that you need to know. Now, go and consult with your family, with knowledge keepers, with the elders. And when you're ready to make a voluntary request for any of these services, you can come back to us and ask. It is contextual, of course. NWAC favors not just free, prior, and informed consent, but free, prior, and informed choice. And so in different situations, acknowledging that not everybody accesses healthcare the same way when they are under the thumb of systemic discrimination. Where there is an opportunity for advanced, free, prior, and informed discussion to inform choice, NWAC presupposes that those consent thresholds need to be grounded in the FPIC standard, but need to be case-specific and conscious of the marginalization that Indigenous women face when accessing healthcare.
Thank you. Those are my questions.
All right, thank you very much. Senator Carignan?
Merci.
Thank you. I'm looking at the definition of sterilization procedure. In French, it seems to target only young girls, but in English, it could include young boys. Because of Section B, which talks of any other act performed on a person. I imagine that the bill is targeting only young girls, or is the intention also to cover boys? Because we don't see boys mentioned at all in the English version. So I'd like to hear what you think about this.
Thank you for your question. One of NWAC's recommended amendments is actually to add to the preamble to clarify that though this is meant to redress the harms of forced sterilization, to add a bit more of a qualifier as to why that has happened and what some of the colonial impacts has been, specifically for Indigenous women. But I think what you're asking is in terms of interpreting the differential between English and French. I would say that the access to healthcare and to free, prior, and informed consent is a human right irregardless of gender, and that it should be freely accessed by anybody, regardless of their intersectional identity as an Indigenous man, woman, or gender diverse person.
Same things?
I would agree.
OK. Mon autre point.
One other thing, usually in bills, offenses that concern sexual activities or intimate activity carry provisions to protect the victim. Maybe there's in-camera proceedings, publication bans, preventing an accused to cross-examine the victim. There are various provisions to protect the victim. Do you believe that such orders should also apply to this new offense so that the court could have the authority to protect the identity of the person and the integrity of the proceedings?
NWAC's opinion is that this bill doesn't need to be amended to reflect the hypothetical that you're presenting because there already exists legislative framework for navigating that specific issue.
Spécifiquement.
But it's not specifically provided for because this is a new section and it's not added to the list for protection orders, to the list of items for protection orders. So should we add 268(1) so that the judges should have the authority to provide those protections?
I think in the interest of advancing the bill through this legislative process, NWAC doesn't propose that specific amendment if it delays its enactment. And in terms
Will not
of
delay.
protecting the victims as you're in the situation you're proposing, I suggest that might be putting the horse before the cart, and it would be prudent to see whether or not this bill in fact does help protect victims of forced and coerced sterilization. As my predecessor at NWAC reported to the Senate Committee on Human Rights in 2019, murder is illegal, but it has not stopped the onslaught of murdered and missing Indigenous women. And so I think where the primary focus of this bill is to criminalize conduct that heretofore has been allowed in policy and in law, that the primary focus is to make sure that there is a penal sanction for those who would commit this act of genocide.
Je suis pas sûr que ma question était.
I'm not sure you really understood my question. The objective is to further protect the victim by allowing the protection of their identity, preventing a situation where we put the accused directly in front of the victim to protect the victim. So I imagine that you have no objection to that. Did you misunderstand me?
Has brought more clarity to that, and I think I'm on the same page as you now. Thank you for restating.
Okay.
No, NWAC would not object to that.
Thanks very much. I have a couple of questions for Ms. Nyman from the Native Women's Association of Canada. First of all, I'd like to just discuss a bit your recommendation about the need to clarify what's required of a physician when obtaining consent for a sterilization procedure. And that proposal aims to ensure that patients are fully informed of their options and the potential implications of such procedures, so to allow for a clear understanding and truly informed consent. Can you provide us some more details on how you would see that integration of that recommendation into the text of Bill S-250, and what clarifications do you suggest so that the obligations of physicians regarding consent are explicitly defined in the law in a way that strengthens patient protection but also ensures legal security for practitioners?
Thank you. In answering your question, I'm still thinking of what the witnesses on the panel before us said, that many physicians don't realize that this is a problem. And so what that's making me think of in terms of an approach, I think that one of the suggestions we would make is that there be collaboration with provincial bodies and licensing authorities to ensure that there is a clear threshold on what prior and informed consent looks like, and that there should be a positive obligation for physicians to demonstrate that they understand what that threshold is as a qualifier for maintaining their license. I know that's a high bar, but I think it's not a high bar when you consider what the repercussions are. And in terms of clarifying that threshold, Across Canada, we are continuing to clarify what consent thresholds are. And in this situation, I think having a conversation before the person gives birth, where that's available, where there's an ongoing relationship between a care provider and a patient in obstetrics, having that conversation beforehand, presenting options, whether that comes from the patient asking or the physician introducing them, and giving space for the patient to then meaningfully consider those and then come back and, in demonstrating their autonomy, say what their choice is. That's the kind of threshold that NWAC is looking for.
So in this bill, S-250, there are two different offense sections. One is subsection 2, which is about the performing of the sterilization procedure, and in that one, it says that that person would be potentially guilty of an indictable offense and liable to imprisonment for a term not exceeding 14 years. And then subsection 7 is about the coercion of sterilization. And that's a different offense. It still has the same, like potentially guilty of an indictable offense and liable to imprisonment of a term of not more than 14 years. What's your comment about the feasibility of having those two sections split like that? And would you think that it's perhaps a better scenario to have it in the same section but defined like that? And what is also your impression of the potential sanction part of that?
Thank you. In terms of the decision to bifurcate those two sections, and I think throughout the discussions in this committee, the phrase has been forced or coerced consent, recognizing that those are distinct approaches. And I think the legislation as drafted reflects the possibility for there to be a spectrum of what coercion looks like and consent looks like without having to define one from the other, which allows for flexibility on a case-by-case basis. Some of the examples in Senator Boyer's report, for example, would reach the level of non-consent, but don't quite reach the level as prescribed here. You know, they're not unconscious, for example, or they don't have mental capacity. And I think where there could be an argument on one side or the other, this will allow those enforcing their rights and affirming their rights not to be forcibly or coercively sterilized will have that flexibility under the bifurcation. In terms of the penalty, I also feel that NWAC's position is that this is relatively preliminary to anticipate what the penalty would look like because nobody has ever been charged with these offenses before. And so I don't want to comment on the appropriateness of sentencing a doctor to doing this because our concern has been more the appropriateness of redress and reparations.
Fair enough. Thank you very much. All right. We have 3 senators left who wish to ask questions. We'll start with Senator Klein, and then we'll have Senator Clement and Senator Simons.
Thank you, Chair, and welcome to our guests. You know, it's puzzling to understand how this type of assault, forced and coerced sterilization can occur. And it just begs the question of when you think about the bill's objectives and the aims and criminality that's attached to this, you would think that would serve as a deterrent. But as well, you would think that protocol and surgery should be an assurance of compliance that the hospital and doctor will comply. And Ms. Neiman was just kind of touching on this in terms of getting the appropriate consultation and or assistance that should be obtained whenever possible, but also that prior informed consent should come through medical staff carefully explaining the surgery to the patient before they have it, including why the patient is having it and any risks of having the surgery and what to expect afterward, but also advised of any viable alternatives for the patient's consideration. And it would seem that, and then and only then should the patient be asked to sign an informed consent form. So my question is, how can the legal community collaborate with healthcare professionals, policymakers, and civil society organizations to ensure that this bill reflects a comprehensive and rights-based approach to preventing this criminality and also ensure justice?
You want to speak on consent?
Yes, I think there are obviously standards in law and standards in practice that should reflect what you have just set out as the ideal, what practitioners should be doing and explaining the procedure that they're proposing, the options that are available to a patient, and ensuring that all of those steps are taken to reflect prior and informed consent, certainly. To the collaboration with legal professionals, civil society organizations, and physicians, I think there will certainly be a role to play if this bill is passed to ensure knowledge and compliance and the adoption of appropriate standards and guidance from medical associations to those that they govern who are providing healthcare services to ensure compliance with the standards of consent that are set out in this bill. And it is certainly our hope and expectation that having a very particular, well-defined, narrow and clear definition of what is and is not permitted when it comes to sterilization and how it must be carried out will provide a deterrent effect to those who are able to provide sterilization procedures, not to do so unless those specific requirements have been met. So I think there is a real deterrent effort and consequence here that would result in the passage of this bill.
Thank you.
I would see your call for collaboration and raise you the importance of making sure that collaboration also includes Indigenous communities. The thresholds for consent haven't worked in their favor up until now, and so the solution moving forward must consider that Indigenous legal orders and Indigenous communities have different concepts of what consent is, and in order for this genocide to stop, at least through the avenue of forced sterilization, their collaboration needs to also be prioritized.
Right, so we will go to Senator Clemmel and then followed by Senator Simons to conclude. Thank you.
Thank you, Madam Chair. You two are always great witnesses, and I echo Senator Delfon's comments. We welcome your repeated visits here. It's always helpful. I want to ask you about the disconnect between this bill and what Canadian society understands. You know, my nieces and nephews have taken an interest in Senate work. I love it. Thank you to them. And when I told them about this bill, they were like, I don't understand. This is happening. They're shocked as young people. And then, I'm not sure what you watched yesterday in terms of our meeting, but we got a message from the RCMP saying they weren't going to appear here as witnesses. Allegations of forced sterilization are relatively rare in Canada's overall criminal landscape. In 2019, the Standing Committee on Health was informed that no allegations of forced sterilizations were found to have been reported to the RCMP. Okay, so maybe that's correct, but is it rare? What do we know? So you both mentioned data collection in your opening statements. What would that look like? How should that be done? Is that the answer to this disconnect? Because we've heard evidence and seen the research of Senator Boyer that speaks to the contrary, that this is not that as rare as the RCMP is saying.
I mean, absolutely, and I would, if you don't mind me.
Yeah.
Yes, I mean, we'll start by stating what I think is the obvious, that measuring the prevalence of this sort of conduct by reports by the Indigenous women who are disproportionately impacted by it to the RCMP, given the RCMP's role and history in the existence of systemic racism. I mean, I think we all would agree that is not an accurate measure of the prevalence of this practice. So I will defer to Ms. Nyman to speak about the way that data collection could proceed to gain a true understanding of the prevalence for this, given it is one of the recommendations, of course, that she put forward.
Thanks. Data collection is one element, and it would certainly need to be Indigenous-led and survivor-led to inform a fully trauma-informed practice, because as you've heard through Senator Boyer's work and before this committee, revisiting those issues is incredibly traumatic, and it is not NWAC's interest to put anybody through more harm than they've already survived. I'm not surprised that many Canadians haven't heard about this, because that means colonialism's working. As the researcher Karen Stout said, the reason that Indigenous women are forcibly sterilized more than non-Indigenous is because then there will be fewer of them. There will be fewer to have land-based rights that the government then is obligated to affirm and recognize. And so it's no wonder that people have not heard about it when it hasn't directly affected them. And there's the cloud of shame over those survivors who have been hesitant to share their stories because they take on a personal responsibility for it as a mechanism of ongoing genocide. So it's working. But in talking about these stories and tabling this legislation and holding Canada accountable and providing redress and apologies and reparations, we disseminate the effect of those genocidal activities.
Thank you both. Lastly, we'll have Senator Simons, please.
Madam Chair. I wanted to say, Ms. Neiman, I thought that the ideas that you outlined in your opening presentation are fantastic and perhaps even more effective than criminal sanction. And some of the stuff you're talking about is absolutely common sense. To have interpreters that wouldn't just be for, speakers of Dene and Cree, but for speakers of Urdu, or, there's so many women who are affected by this. I shouldn't say affected by this, but affected by the inability to understand what they're consenting to in a variety of situations because of language barriers. And I thought what you had to say about education and language interpretation and other forms of access, because really to correct this problem, sending someone to jail is probably less effective than a more holistic look at why is our medical system not delivering services equally to people, men and women, on the basis of the where they stand in the intersection of intersectionality. Having said that, I want to ask my question to Ms. Rick. One thing we haven't talked about today, although we talked about it yesterday, is the final clause of the bill, which deals with coercion. And it says that anybody who coerces someone to have sterilization could be subject to criminal sanction. And when speaking with Justice Department officials yesterday, I said, so that could be a husband, a wife, a mother-in-law, a social worker, a school guidance counselor. It could be all kinds of people. And I'm wondering if you have any concerns about the broadness of that, especially because the bill doesn't define coercion.
I'm just bringing up the language right in front of me so that I have it as well. I take the point, and I think there is a need to ensure that whatever this bill looks like in its final form, it is carefully tailored, and that it is something that has a narrow focus and a narrow scope. I know that also, for example, in yesterday's exchange, I know that you were asking questions, or I understand you were asking questions about relation to gender affirming care as well, and I just wanted to also take the opportunity to encourage the committee to consider hearing from folks who are leaders within trans organizations that are specifically trans-led as well.
Asked for that as well.
Wonderful.
But I guess, so this is where I'd like to end then. I mean, you've said that you would read the bill as very, very narrowly only dealing with cases where the single primary goal is sterilization for the purpose of contraception. My concern is that it says something fuzzy about that, but it also says, as sort of the primary foundation, that Section 45 doesn't apply, that every single sterilization is illegal until proven otherwise. And I'm wondering if that doesn't strip doctors of the traditional protections they've had, and if it might not create a chilling effect where, LEAF has fought for generations for women to have access to reproductive care, including the right to tubal ligations at a time, in my mother's generation, she needed my father's permission to have a tubal ligation. And I'm really worried about a chilling effect where doctors are going to say, you know what? this language is murky enough that I'm not going to offer this service to anybody because I don't want to accidentally get caught up in criminal sanctions for doing my professional job.
And I think that is something I would go back to the comments of Doctors Rawson and Cashin earlier, although understanding the sort of limitations that they put themselves on their own comments here about their comfort with the language that is included here as well. I think what we are concerned to ensure is that any law that would criminalize a sterilization that is forced or coerced, again, that primary purpose language being important, that it is clear also that there are not prohibitions, for example, and chilling effects. I agree, not having chilling effects on the ability of a physician to discuss with the patient options,
Yeah.
the full suite of options that are available to them.
We worried about that too. Yeah.
And I think that I would say if there is clarifying language that would help to ensure that that is the case, while also getting at the heart of the harms, the significant harms that have been done to Indigenous women, in particular, by this practice over the years, that would be, I would suspect, welcomed by the physicians and healthcare providers who are doing this work on a daily basis. But I would also say that we would want to ensure that there is clarity in the steps that can be taken to get to the point of a fully consensual legal
Because I think
proceeding.
I think the steps in 5 and 6 are good. I just worry about, the bread on either side of the sandwich.
Thank you. Thanks very much again to our witnesses for taking the major time to be with us today and to answer our questions. And if there are no other questions or matters that members around the table wish to